Hello, my name is Michael Tesoro, and I prepared this ACCC Video Case Note on the recent case of ACCC and Fujifilm Business Innovation Australia, which was handed down on the 12th of August 2022. And in this case note, I've decided to obviously talk about the case, but as there's not a lot of law in the case, I thought it might be an opportune time to run through both the current UCT laws and the proposed amendments to the UCT laws, which are likely to come into effect very shortly. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Legal Consulting, for the last 14 years, and I help companies with competition and consumer law matters. I've also done quite a bit of work in the UCT area, including providing advice to a global computer company on its standard form contracts. I reviewed 17 separate agreements to identify any terms which I believe may be unfair and provided advice as to whether those terms needed to be changed or removed from their agreements. So I've got some practical experience in this whole process. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. The outline of the presentation, I'll start with an introduction, very short introduction, and then discuss the current UCT laws, then look at the judgment of Justice Stewart, followed by an outline of the proposed changes to the UCT laws, and then finish with some commentary. Now, the ACCC took legal action against Fuji back in October 2020, and as you can see, the ACCC alleged that Fuji had a total of 9 different types of standard form contracts which they were offering to small businesses, which contained 173 unfair contract terms. And the ACCC alleged that of those 173 unfair contract terms, there were 31 different terms which they believe were unfair. So there's a lot of duplication, obviously, between different Fuji agreements. And they provided 3 examples of their concerns. Firstly was automatic renewal of terms, excessive exit fee terms, and unilateral price increase terms. Now, the current UCT laws have been around since November 2016, and there's quite a lengthy process of ticking boxes to determine whether laws apply. There's 7 steps. So I'll go through each of those steps. The first is whether there's a standard form contract. The second is whether it's a small business who's received the contract. Thirdly is whether the contract value thresholds have been met. Fourth is whether there's any general or specific exclusions. Fifth, is the term unfair? And that's actually the substantive analysis of the term. Sixth, whether the term is transparent. And finally, a look at the whole contract to work out whether the term is unfair in the context of the whole agreement. So when determining whether a term is a standard form contract, the main issue you're looking at is whether it's been offered to a customer on a take it or leave it basis. So effectively, one party has provided the agreement to the other party on an understanding that they're going to simply sign the agreement, return it, or not return it. These agreements are described in other jurisdictions, such as the US, as contracts of adhesion. So the factors you look at is whether one of the parties has all or most of the bargaining power. Further, whether agreement's just been prepared by one party before there's been any discussions with the customer about the contract, and then sent to the customer with an expectation they're just going to sign it, return it, and there's no effective opportunity by the customer to negotiate any of the terms. Another consideration is whether it's a generic agreement which hasn't been tailored to take into account the specific characteristics of the customer. So if those requirements are met, then the agreement will be classified as a standard form contract. The next step is whether the customer who's received the contract is a small business, and that's determined by the number of employees the customer has. So if the customer has 20 or less people working for them as employees, which includes casual employees, then it will be classified as a small business customer. Then you have to look at the statutory value limits, and there's 2 limits that apply. For 1-year contracts, the contract cannot be more than $300,000 in value, or for a multiple year contract, it can't be more than $1 million in value. So any contract values which are above these amounts will mean that the contract is outside the scope of the legislation. The next step is to work out whether there's any general or specific exclusions. The two general exclusions, the first is whether the term relates to the upfront price payable, and the second is whether the term defines the subject matter of the contract. So you can't allege that terms that deal with those two issues are unfair because they're the very essence of the contract, how much you're going to be paying and what the contract is for. Then there's specific exclusions. The first is any terms which are required or expressly permitted under a various government law. Then there's a range of exclusions in relation to the shipping industry, marine salvage, towage, charter party agreements, and contracts for the carriage of goods by ship. And then a final exclusion in relation to constitutions of companies, managed schemes, and other bodies. One exclusion that applied earlier was in relation to insurance contracts, but that has been changed and insurance contracts are now covered. We get to the stage now where we're actually looking at the substantive issue, is the term unfair? And there's three considerations. The first is whether the term would cause significant imbalance in the rights of the parties. So if a term gives one party a significant benefit and the other party significant detriment, then it's likely to be unfair. So if one party is a large company with a lot of power in the market and the other's a small business, then there'd be likely to be an imbalance in the parties' rights and obligations. Also, is the term reasonably necessary to protect the legitimate interests of the stronger party? So if the stronger party can't point to a clause and explain the legitimate interest it's seeking to protect by that particular term, then there's a likelihood the term will be considered to be unfair. The final requirement is that the term would cause detriment, whether financial or otherwise, to a party if it were to be applied or relied upon. And there's two issues there. The first is that the term does not actually have to be imposed or enforced to be considered to be unfair. Rather, the term has to have the capacity or potential to be unfair if it were relied upon. So you can generally get an agreement, look at it on its face, and determine whether it's unfair without there being any suggestion that the term is being enforced. The second thing is that the detriment arising from the term does not have to be financial. It can be other forms of detriment. Then you have to look at whether the term is transparent. These are factors that probably add to the conclusion that a term is unfair. So if a term is not expressed in reasonably plain language, legible, presented clearly, or readily available for the party, there are additional factors which mean that the term is unfair. Then the final step is to look at the whole contract and to look at all the rights and obligations that apply to both parties, because conceivably there could be a situation where one party benefits from a certain number of terms and conditions and the other party has benefits from other terms of the contract, and they sort of even themselves out. So the requirement to have a look at the whole agreement before making any conclusions that an agreement is unfair. Now, moving to the Fuji judgment, the first issue to realise is that after contesting the case for a couple of years, Fuji consented to a settlement after a successful mediation. So they agreed that the ACCC allegations that terms were unfair was valid, and they consented to orders. So the court declared there were unfair contract terms both within the meaning of Section 24 of the ACL, the Australian Consumer Law, and Section 12BG of the ASIC Act. And the reason for that was because some of the agreements related to goods and services and others related to financial services. So that is within the jurisdiction of ASIC. So what happened here was ASIC gave the ACCC a delegation to take action in relation to the financial services agreements which were under its jurisdiction. That's why there's orders under both the ACL and the ASIC Act. Furthermore, the court declared that those particular unfair contract terms were void by operation of Section 23 of the ACL and Section 12BF of the ASIC Act. Now, somewhat disappointingly, the judge concluded that he did not need to consider the merits of arguments that particular terms were unfair, and he expressed it in paragraph 7 as follows: given that there are nearly 300 individual terms that are impugned and that they are unfair in the context of the whole of each agreement in which they appear and cannot be assessed in isolation, it would be a substantial task to set out the reasoning in respect of each term, and little would be gained from doing so. So effectively, he didn't go through each term and look at them and assess them according to the criteria set out earlier, which is disappointing. And I think potentially not as hard as he suggested, because there were 31 impugned terms, not 300 terms. There was a lot of duplication. So it would have been feasible for the judge to go through those 31 terms. And clearly, the first requirement is whether there's a substantial degree of differential bargaining power between the parties, which could have been decided as a global issue. The real interest would have been factor two, whether these terms were needed to protect the legitimate interests of Fuji, and some case law on that would have been very helpful. And then the final issue could also have been determined quite globally, in the sense that these terms were likely to cause financial detriment to the small business consumer. So it is somewhat disappointing that the judge didn't at least go through the 31 terms in relation to the second factor. So the judgment concluded that between November 2016 and December 2021, Fuji entered into 21 template contracts, which were defined in the judgment as the capture contracts. The interesting thing there to note is that it appears that there was no effort by Fuji to actually review its standard firm contracts in the context of the UCT laws coming in November 2016. The court also concluded there were 34,000 contracts in this particular class which were entered into or renewed, and a number of those contracts were still in force. And finally, the parties, neither the ACCC or Fuji, were able to identify how many of these 34,000 contracts were actually small business contracts. So Fuji had no way of knowing whether the customers that it had contracted with had 20 or less employees at the date that they signed the contract. So that was an issue that had to be worked out in the context of the orders. Now I'll go through the terms that were found to be unfair by the court, but this is subject to the proviso that it was by consent and the court didn't go through each of these terms individually. The first was a term which allowed Fuji to unilaterally vary either the price or the rights and obligations under the contract. So that does sound pretty unfair. Any clause which gives one party the right to unilaterally vary any aspects of the contract is very likely to be found to be unfair. The second was an automatic renewal clause, which basically required the customer to provide quite a lot of notice of their intention to renew the contract, and failing providing that notice, the contract would be automatically renewed. But there was no obligation on Fuji to notify the customer when the renewal was due. The third term was one that incorporated additional contractual terms into the contract, including extraneous documents, which were very difficult for the customer to locate or identify. And Fuji also had the power to unilaterally vary those documents, which would have the impact of varying the contract. So again, this unilateral right to vary the terms of the contract is found to be unfair. Then there was a limitation of liability clause, which effectively excused Fuji of liability for any delay in supplying or delivering equipment to the customer, but the customer had no right to be excused from paying the charges, even though Fuji had delayed in supplying and delivering equipment. The next term was a right for Fuji to recover costs from enforcing the contract on a full indemnity basis. And again, there was no corresponding right for the consumer to recover such costs. And further, there was no obligation on Fuji to minimize the costs it spent on enforcing their contract. So as you can see, that could result in quite a large bill to the customer if it's on a full indemnity basis. The next clause, I think, was particularly problematic because it was a warranty by the customer that they'd read all the documents, including a number of extraneous documents that are referred to in the contract, but also specifically documents which Fuji may not have provided to the customer. So that the customer warrant that it's read documents which it doesn't even have in its possession is clearly problematic. There was also a term which said that liability was excluded for any pre-contractual representations. I think that's an important term to look at because it's very common to have whole agreement terms in contracts, and this seems to be a finding that title agreement terms can be unfair to the extent that they're saying that something which did happen, i.e. a pre-contractual representation, has not happened, and accordingly the documents are the only record of the agreement between the parties. So I think title agreement clauses are likely to be struck down as unfair contract terms in most cases. Then there was a provision that a significant cap, reduction or limitation on Fuji's total liability would apply, and that it would also exclude any claims for consequential loss. But again, the customer did not have similar ability to limit their liability. The next term was a requirement for the customer to indemnify Fuji for loss or damage to the products, and effectively Fuji would be liable for negligence, but would not be liable for any other loss caused, including accidental damage caused by Fuji. The next clause said that Fuji was able to suspend the provision of services to the customer if the customer breached any term of the agreement, but that the customer, even though they're suspended, were required to continue paying for the services. A further term saying that Fuji had a right to terminate the contract immediately on notice and for cause if the customer breached any term of the agreement, which is somewhat unusual, usually to focus on material terms or essential terms of the contract, but this was any term. And the customer did not have a corresponding right to terminate the agreement. Their rights to terminate the agreement were much more limited. And further, there was no specific right for the customer to take steps to remedy the breach. Then there was also a term that provided for payments to Fuji upon Fuji exercising a right to terminate the agreement, which extended to paying out the remaining term of the contract. So if Fuji exercised a right to terminate, the customer could be liable for the remaining period of the contract, but also the customer could forfeit any prepayments which they had made. Then there was this sort of strange agreement, and I think a term, and I think it worked with a couple of terms together. Firstly, it provided that if at the end of the minimum contract term, a customer could either stay in possession of the equipment and pay the residual value, or could pay Fuji the shortfall between the residual value and the market price. And the problem with the first particular term was there was another term in the contract which said that the customer would never receive title in the equipment. So you've got the situation where they're paying the remaining possession of the equipment, paying the full residual value, but not acquiring title. And I personally think that might have been a mistake in the agreement. I think that should have been amended because it doesn't make any sense. But the second clause is a problem as well because it's saying that if there's a shortfall between the residual value and the market price, the customer has to pay that. But then it says the market price is as determined by Fuji. So it gives Fuji the ability to determine what the market price is, which suggests it's not truly a market value. The final two clauses is as follows. Firstly, that Fuji had the right to state that the customer was irrevocably bound by the contract once they'd signed it, but that Fuji was not bound by the contract until it advised the customer that the contract had been accepted, or until Fuji commenced providing the service. So it's a strange sort of thing where effectively one party's bound immediately on signature, but the other party is not bound until they sort of decide they want to be bound. So that was a differential term which obviously benefited Fuji and not the customer. And the final one was that Fuji could invoice the customer regardless of whether the goods or services had actually been provided to the customer. So they're the terms that were considered to be unfair and found to be unfair by the court. And so I think customers, businesses have to be very mindful of those terms and look through their agreements for any terms that look similar to those particular terms and need to either remove them or amend them. The remedies ordered in the case were interesting. The first was a requirement on Fuji to write to all its customers, the 34,000 customers, to ask them some questions about the number of employees that they had at the date they entered into the contract, because that would determine whether they were small business customers and whether the UCT laws applied to them, whether accordingly the relevant terms were void and unenforceable. So they have to write out, find out whether these particular customers are small business customers, then advise them that specific terms in their agreement are void and unenforceable. As I said earlier, there was declarations by the court that particular terms were void as being unfair contract terms. Also, injunctions were ordered restraining Fuji from relying on these terms in their relevant agreements, so the agreements that apply to small businesses. Also, injunctions restraining Fuji from using these terms in the future in their agreements as they apply to small businesses. An obligation to publish corrective notices on various sites, websites. An order requiring Fuji to establish a compliance program, which suggests they didn't actually have one in place, which is very surprising for such a large company. And then finally, a contribution of $250,000 to the ACCC's costs. Now, I'll go through the proposed changes to the UCT laws quite quickly. There's 4 major proposed amendments. The first is changing the small business threshold, removing the contract value thresholds. The second, introducing pecuniary penalties, and then streamlining the powers of the court. Now, the first significant change is an increase in the threshold to be considered as a small business, and that is rising from 20 employees to 100 employees. So that's a 5-fold increase. There's also an alternative requirement is that the turnover for the company is less than $10 million. So as you can see, that's going to result in many, many more companies being caught as small businesses under legislation and thus gaining the benefits of the UCT legislation. So this is going to become a much bigger issue for many more businesses. In the past, businesses would have to be concerned about any of their customers who had 20 or less employees. Now they're going to have to be worried about any customers who have 100 or less employees. So a large number of contracts are going to have to be reviewed, much larger than was previously the case. The second change was to totally remove the value thresholds. So as I said earlier, the current thresholds are $300,000 for a 1-year contract or $1 million for a multiple year contract. Well, both those requirements are being removed. So as you can assume that, as you can expect, that's going to result in many, many more contracts being caught by the legislation. And the rationales provided for why they're removing this is firstly that the upfront contract value threshold had been eroded due to inflation, which seems pretty accurate at the moment with inflation rising, but also there were cases where the upfront price of a contract was not available at the time of entering into a contract and could fluctuate. And that was a valid reason to look at the thresholds and remove them. Quite simply, there were just too many steps to get to the substantive analysis. So removing this threshold does make it a lot more simple to actually get to looking at whether the term is unfair. A very significant change is that the terms will no longer just be voidable, they will actually be illegal, and there'll be significant penalties as a result. And the current proposal is for the penalties to be subject to the standard penalty regime under the Australian consumer law, which is $10 million, 3 times the benefit, or 10% of turnover, whichever is the highest. So that's a very large penalty, and I know some submissions were made to the government that a lower penalty should apply to these particular contraventions, but that was not accepted. So that is a very significant penalty for this particular conduct. And there's also talk at the moment of increasing these penalties even more, and it could apply to the UCT laws. and that could make it even more painful for businesses. So businesses have to really take note of these proposed changes. There are also proposals to streamline the powers of the court, and these are fairly technical, but effectively the government wants to bring in powers for the court to make a declaration to solve problems across a range of industries. I guess the concern is that sort of a bit of a whack-a-mole approach to dealing with unfair contract terms, and if a court could make a declaration that a particular term is unfair because it's similar to another term used in another context, that would streamline the process. Further, preventing people from using a term which the court had considered to be unfair that was similar would also make enforcement a lot easier. There was a proposal in the earlier legislation under the Morrison government for a rebuttable presumption that would apply across industries, but that was abandoned in the draft legislation when it came out. So that was a change that would have caused even more concern amongst business. There's also some further guidance as to what a court can't consider as being relevant to their assessment. So effectively, they're not permitted to consider whether a party had an opportunity to negotiate minor or substantial changes to the terms of the contract. So effectively, if a company says, hey, there was an opportunity here to negotiate a minor insubstantial change, it's not a standard form contract. The court is not permitted to give that much weight. Furthermore, it won't take it outside the range of or the definition of a standard form contract if a party had opportunity to select from a range of options. So ticking boxes of various options does not make for a proper negotiation. And to the extent to which a party to another contract or proposed contract was given an effective opportunity to negotiate the terms of other contracts or proposed contract. So the fact that a party was able to negotiate a related contract would not make another contract fall outside the definition of a standard form contract. So this is more guidance for the courts to help them define what is a standard form contract and therefore what is covered by the legislation. So just a bit of commentary very quickly. Firstly, it is relevant that the court has found, admittedly by consent, that these terms are unfair. So I think companies need to go through their terms and conditions and see if any of the terms that were of concern in the Fuji case are in their standard form contracts. And if so, they really need to look at those. There's two approaches. You can just remove them or you could seek to amend them, mainly to make them apply to both parties, not just to one party. So if there's a commensurate right provided to the customer, then it's unlikely to be unfair. It is disappointing that the judge didn't provide any real guidance in the judgment on the unfair contract term issue, particularly the legitimate business interest factor, which I think is an important factor on which we need some case law. But I guess it didn't happen, so we can't complain too much about that. The proposed changes are going to be very significant for many businesses. Not only are the range of contracts that are covered and the number of customers covered by these laws going to increase exponentially, but there are going to be very large penalties for breaching these laws. So if companies haven't been proactive in looking at their terms and conditions and getting advice on what needs to be removed and changed, they need to do that as a matter of urgency, because the ACCC is going to be going out there very aggressively and as well, I assume, and taking enforcement action against any parties who have not reviewed and amended their standard form contracts. If you look at the Fuji case, the results under the new laws would have been substantially different. There would have been a lot of findings of illegal agreements. They could have been liable for 31 breaches of the legislation and a penalty potentially chargeable for each of those offences. So just looking at that factor, if 31 separate terms could have been fined, and that could have resulted in an enormous fine. So the result would have been a lot different. I think also the new changes have been in. I think Fuji may not have consented and would have fought it to the end. But clearly the penalty ramifications are significant, and companies need to really be proactive on this issue. Final question is, I was a bit puzzled by Fuji's litigation strategy because it got sued in 2020 on the basis of written contracts. So there was no evidence required from particular witnesses in the case. And I don't quite understand why it fought the case for 2.5 years and then consented to the orders. It seems to me that the case was laid out initially. Potentially it became worse. It seems there might have been some additional contracts added in there as the case moved forward. And it seems to be one of these cases where you make a quick decision at the beginning to either give up, settle, or fight to the end. This sort of middle of the road approach where you fight a case for a couple of years, spend a vast amount of money, and then consent to orders is something I simply don't understand. But anyway, there probably are some good reasons for the particular strategy they adopted, so I probably shouldn't seek to second guess that. So that's all I had. Hopefully that's been helpful. I think the main thing is to understand how the proposed changes are going to work, and if you're a business, to quickly look at your terms and conditions and be very strict on how you do it. There's no point taking a chance on a term. If you can't see a term is needed for protecting your legitimate business interests, you really should get rid of it. So if you've got any questions about this presentation, feel free to give me a call or send me an email. Bye-bye.